Christof, you've been leading the AIPPI UPC Standing Committee, so I know that you know a lot about this area. What are you seeing in terms of the types of organisations that are going to leave their patents in the UPC system? And what are you seeing in terms of trends of those who are considering opting out?
Well, what I see is that you really can't tell, between organizations, because what I see is that in particular the bigger corporates and the more sophisticated clients, they take an approach of what we call like a mixed litigation approach, so that they look for members of particular patent families where they're, some of them leave in the UPC system, and for some they opt out. And actually, that's also what we recommend, because that gives you the best of two worlds, meaning you can have patents with, very similar technologies. As we all know, you have patent families where the single members can only have one or two additional features. So the basic concept of the technology is the same. So which means that most likely a product is infringing both patents. And so you have one in the UPC system and you have one in the existing national system. So you can, go in parallel. I think that's feasible. There's some concern under German law where we have a provision that you must assert all the patents at one time. But I think this is limited to German law, so I don't see any major issue with that. So therefore, the mixed litigation approach is, I think, really the way to go. And that means not really a decision between the two systems, but, being capable to react flexibly on any challenge that you might see. And therefore, just having the best of both worlds. And when we talk about numbers, the numbers I know and the numbers that are publicly available of big corporate clients, so the opt-out is surprisingly low. At least for those more sophisticated clients, they clearly want to use the new system. It's questionable whether they really go there with their crown jewels, with the very best patents, because of course, validity in the whole of Europe is at stake. So that's probably not what you want to risk with your crown jewels. But that clearly, maybe for some not so important patents or for some divisionals, as I just said, for the mixed litigation approach, they will definitely use the UPC system. And then, I expect that we'll see a lot of cases when the UPC starts, yes.
Do you think that the UPC is going to be a second-rate court with all of the valuable patents opted out? Or do you think it's going to have a significant role to play now before unitary patents come into effect?
Well, I understand the question kind of twofold, because, unitary patents, of course, is something that will develop over the next couple of years. And, this is, more persecution filing strategy, and there are different interests, different issues to balance. So I'm rather hesitant to already now call the unitary patent a success, so that there will be many coming up, because the cost of this patent is rather high and maybe higher as many people have anticipated. So therefore, I don't think that, the unitary patent as such will play a significant role in the very first years or in the first 5 to 7 or even 10 years of the UPC. So what we see I expect will be mainly litigation on classical European patents. And the second part of the question, I understand, was, about, the value of the patent that will be litigated. I think, when we look at pharma industry, I think that blockbuster patents, meaning the patents cover their blockbuster products, they will be certainly opted out. So, those patents you won't see there, because, as I said, the danger that, they're going to be revoked is just too significant, and they want to mitigate the risk in that perspective. Apart from that, when you really follow this mixed litigation approach, you have, of course, also some important technologies covered. And that means, even if you lose one, you still have something that would cover it, preventing competitors probably of copying your product or, getting as close to the technology you consider yourself to being very valuable. So therefore, in that respect, I think that people are probably not that hesitant to also enforce important patents at the UPC. Yeah. So therefore, I don't think that the split of opt-out and not opt-out is just that you say, well, the valuable patents will certainly stay out of the system and only just the ones that we don't care will be litigated at the UPC. So I don't expect that, I must say.
Some of the commentary around the UPC suggests that it could be a favoured forum with NPEs, so non-practicing entities. It could be a new Western District of Texas. What are your thoughts on that?
Well, of course, it's tempting for any plaintiff to have, maximum pressure and to have, a big market, resolved in one go. And my observations, traveling the world, having talked to people in the US or in Asia, is that they favor the UPC system because, it reduces the complexity of a dispute in Europe. Yeah, they have only one case they need to deal with. They don't need to coordinate like Italy, France, Germany, and whatever other country. So that from that perspective, it's very attractive for those litigants. And, many of the NP companies are located overseas. So maybe that's why they found it attractive to have a forum, where they just, have one case to go and not having necessarily the hustle of coordinating everything. So therefore, I think it's attractive. And of course, the bigger market, when we, even at the beginning with only this 13 contracting member states, but in particular, when we look to the future, when maybe more European countries will join the UPC, we'll have, a market that is as big as the US, at a cost that is still significantly lower than anything you could imagine in the United States. So therefore, let alone this fact, you will find an attractive forum. And I also think that with respect to reliability of judgments or foreseeability of judgments, we'll find the UPC at least having the same quality like US judges. I'm very convinced about that. When you look at the judges that are appointed, you will find all the the names that are well known in the industry that are really renowned judges. So we can really expect that those judgments are of high quality and therefore will be attractive to those litigants. So at the end of the day, I think it will be an attractive forum because you will get more value for less money for sure. Yeah, and of course, decisions from the UPC will have a big impact on any defendant and a much bigger impact than any injunction you will find in Europe these days. And therefore, per definition, I believe it's a more attractive forum for NPEs like for any other plaintiff as well. Yeah. So I wouldn't call it being a particular attractive forum for NPEs, as it will be an attractive forum for any patentee to enforce the patents.
You mentioned the injunction, and I think that's one of the attractive features of the UPC over the current US system, where it's very difficult to get an injunction. But to enforce the injunction, will there be a bond that's payable or a cross-undertaking in damages? Do you know what the mechanism will be for enforcement of an injunction granted by the UPC?
Yeah, well, the enforcement is governed, is foreseen within the UPC agreement. And, when we look at Article 82, Section 4, you will see that the UPC itself can impose recurring penalties on any defendant if the defendant does not comply with any court order. So that means the mechanism for enforcing the decision is already with the UPC. And that is something I think many people do not know yet, because, I must say, when I first came across this rule, I was surprised, because what I heard is that enforcement measure because having kind of a punitive element would be reserved to national countries only. Yeah, but this is not the case. This is clearly not the case because of this Article 82, because it says in Article 82, Section 3, that, what's the precise wording? It says, unless this agreement provides otherwise, national procedure applies along these lines. Well, I can cite this maybe. Without prejudice to this agreement and statute, enforcement procedures shall be governed by the law of the contracting member state. But the important bit here is without prejudice to this agreement. And we have then the next section saying, if a party does not comply with the terms of an order of the court, the party may be sanctioned with a recurring penalty payment payable to the court. So there we have the competence of the UPC itself to impose penalty payments on the other side. So from that perspective, enforcement will be pretty easy. Yeah? You will be with the very same court that has issued the injunctive relief that would also impose the penalty payments on the other side. Things become more difficult when we look at if defendants do not pay these penalty payments. Then we might run into troubles to get, assets seized or, to get bank accounts seized. And then we come again to the national case law, to national procedures, where we need to split up and look, where, at the end of the day, the plaintiff gets the money, or the court gets the money. Sorry, the court is the entity that receives all the penalty payments. Yeah. So see, we'll have a system within the UPC that will be competent to also define penalty payments so that decisions can be enforced right away. So in that respect, very attractive. And maybe when we talk about injunctive relief, the UPC system has a discretionary element for the court. Unlike maybe the German system where we talk about claims and the judges just, double check whether all the requirements are fulfilled and then checking the box. The UPC system is different in the sense that it grants powers to the court. Yeah. So the first thing a UPC judgment will tell you is that the patent is valid and infringed if validity was challenged. And this opens up, all the possibilities for the court to take appropriate measures. Yeah. And one of those measures is injunctive relief. And there is clearly a discretionary element within granting injunctive relief. And, speaking to UK colleagues, I learned that this is pretty similar to the UK system. But even under the UK system, I've learned, in 99% of the cases, maybe 95, don't get me wrong on the number, but in the vast majority of all cases, British courts grant injunctions despite this discretionary element. And as far as I've talked to judges and as far as I learned from training of the judges, it's very much the common understanding of the judges at the UPC that except for very particular circumstances, the UPC will grant injunctive relief. So, I believe on a very general level, we will see injunctions at the UPC. And because you just mentioned the United States, this will be a significant difference. And this, of course, makes it more attractive for any plaintiff to come to the UPC instead of going to the US.
I think in the last few years, some of the top filing organizations at the EPO have been Chinese or Southeast Asian organizations. Do you think that European and US organizations could be crowded out of the UPC by a flood of cases brought by Chinese or Southeast Asian companies?
Well, I think it's hard to imagine how someone could be flooded out at a court because, you can file your cases nonetheless. The question is, how long it will take until you get a decision. But if you think about who's going to be the first movers or the users of the system, I think that we will see not so many we'll see some European companies litigating at the UPC, but I think it will be particularly attractive for Asian and US companies. As I said, it's much less complicated. And for them, Europe becomes much more manageable when it comes to litigation than it was previously. So therefore, I would expect more Asian US companies using the UPC system. Yeah, I think that's a fair estimate.
I think before Patrick asked the question in German, I think that's probably true. And simplifying in terms of language, given that English is a possible language at any of the central or local divisions as well, is going to make a massive difference. You mentioned time to decision. Do you think that the short timescale that the UPC is aiming for to render its decision through the process will make the court plaintiff friendly?
Well, yes, but it remains to be seen whether the 12-month time period until a decision, corresponds to the reality. And given to how many people I speak, I think we will see many, many cases on the very first day at the UPC. So I would expect that, particularly at the beginning, we'll see kind of a delay, and that at the beginning we'll probably be very optimistic to say, well, you get a first instance decision within 12 months. I think that's rather optimistic. And of course, the 12 months is a very challenging timeline, but I would also guess that the divisions at the UPC, they will try to keep that schedule, because of course, there's kind of a forum shopping thing, and you rather expect that the judges will try to have their forum being attractive and, stay within the timeline. And I must say, there's some value to it when you have a timely limited monopoly, such as a patent. As a plaintiff, you of course go to a forum where your decision don't take that long, because otherwise it will devalue your patent anyway. So speed is always of the essence in patent litigation, and therefore I would expect that speed is also of the essence at the UPC. And therefore, I expect that judges will do whatever they can to keep that timeline. And therefore, of course, if in any event we'll have decisions within a time frame of 12 months, that's of course, that's very attractive to any plaintiff. 12 months is really, really fast. And so if they can stick to the timeline, if they achieve to do this, of course, it will be attractive to litigants.
One factor that's really important for funders is to understand predictability of a particular forum. The new UPC as a new court, but with judges which are known in some cases, how predictable do you think it will be in terms of the approach to the cases and the decision making, given that the judges are applying a new set of rules in a new forum, but obviously have their own sort of national flavour coming to their decision making?
Well, that's a difficult question to answer, because it's very hard to anticipate, how cases will be dealt with. Impression is there's many of the stakeholders, lawyers and clients, patent attorneys, very much their national approach in their mind when they're thinking UPC. And only when you talk to foreign colleagues or other European colleagues, you will recognize that there are many, many various approaches to many, identical situations. And so it's really hard to predict, in a case of doubt, what the Court of Appeal at the end of the day will decide on particular procedural issues. So, but this is the concept of the UPC. Unlike in design or trademark cases, we didn't take existing courts to rule on a European-wide level, but the legislator decided to have a new court set up with a completely new set of rules with no precedent whatsoever. So of course there are uncertainties in the system. But I think there are 2 points that will give clients nonetheless a sufficient degree of certainty. The first one is, for a standard case, the rules of procedures are very, very detailed. So you know what to file, and to me, it's sufficiently clear what a court would expect. It's a front-loaded procedure. You have to put your arguments in a written submission. You have to put forward your evidence if you need to rely on evidence. And you will have an interim procedure where the main issues will be identified, and then an oral hearing where it's going to be decided. So for normal cases, it's pretty much straightforward with no big question marks. So I think that's going to give you, for a standard case, enough guidance on how this is going to be decided at the end of the day. The second point, I think, will give you some comfort as a party, is that in the usual countries where you're used to have patent litigation, you have 2 local judges in the local divisions. So for instance, in Germany, in all of the 4 local divisions we have in Germany, there will be 2 German judges and only 1 international judge deciding on the case under some circumstances, or also regular a technical judge, also from a different nationality. But decisive will be the 3 legal members of the panel, and 2 of them will be in Germany, will be German. And of course, you could expect that if you have then a question of doubt, that probably these 2 German guys will think about, how do we do this in Germany? And then we'll, decide probably along the lines of the German case law. The same applies, I think, France. You have also 2 judges at the Paris local division, and you're going to have 2 Dutch judges at the Hague division. But as I said, for the standard cases, I think the rules of procedure have a sufficient detailed framework. And, if you go to a local division with 2 national judges, you have really the most of predictability within the system. And I think then you could dare to go to the UPC.
Christof, are you excited about the new UPC?
100%. When you're a patent litigator, and it's kind of a really, unique, not to say historic, opportunity to really start from scratch a new legal system. And you may know that I have been, working on the UPC for many, many years. So I have liaised with other European colleagues to write a commentary about the UPC. I have other engagements with the UPC, and to me, it's always fascinating and very interesting to approach all these legal issues from various different angles. And I must say, I'm 100% excited to go to trial and to discuss all these new possibilities with the judges and to find out what is the best way forward and be more creative and do everything. So the only thing I need is clients that are willing to pay this. Yeah, because, that's, of course, the other issue. Yeah, this will cost money because, of course, the first cases, they are more comprehensive. And of course, they will cost more money than the ones when we, will be doing in 5 years from now. Yeah. So with that caveat, I'm very much looking forward to it, to have this very intensive discussions with the judges and to try, to establish a very suitable and very modern system to patent litigation.
You mentioned cost, and that's one thing, obviously, for a litigation funder, that's important. I've also seen that there's a legal aid provision for the UPC. What kinds of organisations can make use of that? And do you think that that's available in the early days, given that the UPC is self-funding?
I look up the provisions, so I can cite it. So it's Article 71 talking about legal aid. And unfortunately, maybe for a funding organization, is that legal aid is only available to natural persons. So the specific legal aid is not for any legal person. So unless you have an inventor, with his very private, with his invention, trying to enforce it and may rely on legal aid, that's the only situation where, the legal aid, according to Article 71, will be available at all. Then the next question is, of course, there are other means to reduce the cost for small and medium-sized enterprises, which apply to court fees in the first place. You can apply for a reduction of court fees, and you can also apply for a reduction of the ceilings of the cap of the reimbursable attorney costs. So it's reimbursable costs that are capped at a particular level, and you could ask for lower the level. But, I keep saying this, if I were a plaintiff, I would never apply for such a measure because, it shows weakness at the very beginning. And when you're trying to get to fight with a very big company and you say, well, basically, I can't afford the litigation, I'm just about to start. Yeah, it's just an invitation to countermeasures that will definitely kill you. Yeah, so that's not the way how I would suggest to start with. And therefore, as good those legal aid or reduction provisions seems in the first place, I would think they won't play any practical role at the UPC.
So currently in Germany, for example, there are roles for patent attorneys and roles for litigators within the current system. In the UPC, patent attorneys have standing to represent clients. Who do you think we're going to see litigating in the UPC?
Well, that's, of course, also a very good question. As a litigator, not being a patent attorney, this, of course, also a question that concerns my professional future. I think that clients are well advised to look for experienced counsel also at the UPC level, because I think, this is a civil court, and the patent attorneys dealing with validity issue proceedings, they don't need to rely that much on strategy, on dispute of facts, because the UPC is very similar to the German procedural law, allowing for establishing of facts on a very easy way. Yeah, you need to dispute allegations one party puts forward in order that they are considered to be, not true, or put it the other way around. If you can't dispute a fact sufficiently, this fact is deemed to be true. Yeah, and that is really a civil law procedure issue. And proceedings for patent attorneys, they work at a different principle. The proceedings at the Federal Patent Court and the European Patent Office, they work differently. So you don't need to rely that much on the submissions of the party. And therefore, I strongly believe that the skill set of patent litigators is needed at the UPC as well. And I would say it's even more needed because, as just said, we have the merger of various different legal systems. So at least I would say you should be familiar with one legal system, how civil law procedure works in that particular country. And ideally, you also have some experience with foreign jurisdictions. So you have a better understanding of what issues are at stake and what issues can be dealt with one way or the other. And the UPC decisions, as we've discussed all the time, decisions at the UPC are much more important than decisions on the national level because they are related to a much bigger market. So there's much more at stake at national proceedings. So therefore, again, I would think that clients are well advised to look for experienced litigators, in particular at the UPC, and not to rely on, on people they didn't do litigation cases. So that doesn't mean that there are not talented patent attorneys out there, and I know a lot of patent attorneys, they do a lot of litigation. But of course, I would say they would also be capable of representing clients at the UPC level. But the qualification as such of being a patent attorney, the experience of writing patent applications is surely not enough, in my opinion, to represent successfully a client at the UPC. So I would expect that, litigators will play an important role at the UPC as well. So you will have legal representatives being in the lead at the UPC, in particular because all of the judges, they will be legally qualified, and at any occasion, at every single division within the UPC will have the legal judges being in majority. And the legal judges will always prevail over any opinion of the technical judges, which I would say requires that technical facts and the case law is established in a way that the legal qualified judges will understand it. And again, I don't disqualify all the patent attorneys, but that's the litigator's job been in the past, and the litigators have been trained to do this translation step to the legally qualified judges in the past. So I would still say there is a need of litigators to be involved at the UPC level as well. Would you expect when you funded that those ceilings that are set would actually cover the cost? Or is it for a funder just a factor when assessing the cost risk as being the maximum of reimbursements to the other side?
I think it's going to be the same as when we assess, for example, a case in the UK. There's not a fixed amount that we know is going to be sort of coming back. So I think we would take that into account, particularly because this is an unknown entity. Obviously, economics is really important for us. So we need to get our arms around likely damage and likely budget and make sure that the cost and the damages is going to be viable. So I think we'll be taking a conservative approach in the early days and having a look and seeing what happens in terms of the costs that are awarded and whether the caps are, adhered to, or whether there's flexibility that the judges use when they're awarding adverse party costs. I think for us, another point that we're looking at is the availability of insurance. So often in the UK, we would obtain after the event insurance, or the client would obtain after the event insurance, but the market's very London centric. So how available is insurance going to be for a new court, and how are insurers going to react to the new court, and how willing are they going to be to underwrite that risk is a question. And I think because the risks are higher than the potential in, for example, a German action where you have the statutory scale, I think that could be another factor in that plaintiffs or claimants take into account when they decide whether to go ahead in the UPC or to go at a national level. And also US versus UPC, where the US doesn't have an adverse party cost regime. So I think, the benefit of that kind of regime is that you ensure a higher quality, I think, of litigation. So, vexatious litigation isn't going to be brought in the UPC because of that adverse party cost risk. So I think it will keep the quality of cases higher, but we'll have to see what the awards are that are made as cases come through the system.
Talking about just the reimbursement, does that play any role for you in accepting cases or not? Or is it just out of the balance for your assessment whether to file a case or not? So in other words, do you rather file in the US because you don't have a cost risk, or would you rather file in Germany, UK, or the UPC because you might get a reimbursement if you win?
I think there's two sort of considerations. You might get the reimbursement if you win, but you also may have to pay if you lose. And it's how you would mitigate that downside risk. So we look at the entirety of the case. So we look at the budget and we look at the adverse party cost risk, and we look at what could come back and when, and the timing of settlements and what's likely to happen with costs in those situations. And we build that into our model. And I think so long as the case, whether it's US and no adverse party cost risk or reward, or Germany or UPC or UK, it needs to make sense economically. So we would use the same formula for assessing the case. But if there is an adverse party cost risk, and we would be looking at whether the claimant has insurance for that, or whether we would provide an indemnity for that, which would then form part of the funding. And then we may take that on our balance sheet, or we may seek ATE to cover our own risk.